credible in saying, like, okay, the book is one thing and the movie also is another thing, and we have to make sure that we're not making a replica of the book if it isn't always the best and most authentic choice for the moment. And I think because of that, it's a very true adaptation of the book. Like, it is very, very, very true to the book. And
hey besties, grab your tea because things just got super juicy. Like, we need a bigger cup juicy. Remember all the drama we've been following here on the channel about Blake Lively versus Justin Baldoni Wayfair, and that whole squad of PR people? Yeah, that case. It's been all over the headlines with accusations of retaliation, secret campaigns, and everyone's been asking, wait, wasn't Blake supposed to be in charge on set? What happened to that? Well, here's the update. When Blake filed her second amended complaint and Jed Wallace fired back with a motion to dismiss, I told you at the time that Jed's filing was basically a how-to guide for Wayfair on how they could kick these claims out too. I even wondered out loud why Wayfair hadn't just gone ahead and filed their own motion to dismiss. Turns out they were playing a longer game. Instead of filing the exact same motion, Wayfair decided to go for something called a judgment on the pleadings. Now what on earth is that? Let me break it down bestie to bestie. A judgment on the pleadings is kind of like a motion to dismiss, but not exactly. It's what you file after both sides have already laid their cards on the table, meaning the defendant has already responded and filed an answer. Think of it as the courtroom version of saying, okay judge, we've all shown our receipts, now can you toss out the stuff that doesn't belong before we go any further? Here's why it's a big deal. If Wayfair wins on this, it could literally gut Blake's entire case. We'd go from a headline-grabbing lawsuit full of harassment and retaliation claims to a plain old contract fight between It Ends With Us LLC, Blake Incorporated, and Blake Lively herself. All the sensational stuff? Gone. People keep asking me, what actually happens in a judgment on the pleadings? Basically, it lets the judge look at just the four corners of the complaint and the answer. No digging into evidence yet, just what's already been filed. And not only the words, but also any exhibits attached to the complaint. So if Blake attached her famous 17-point agreement or other documents as exhibits, the judge can look at those too. At the heart of Blake's lawsuit, she's bringing claims tied to sexual harassment and retaliation along with some contract issues. Wayfair's asking the court to decide right now which of those claims are even legally allowed to move forward. Think of it as the last big checkpoint before the case moves into summary judgment territory, where both sides get to bring in evidence from discovery. Judgment on the pleadings isn't always used, but it's a powerful tool for trimming down what a judge will even hear. And here's the strategy. If Wayfair can win this, not only do they chop down her claims early, but if the judge rules against them, they still get a clear record for an appeal later. Basically, they're laying out to the judge, here's exactly what we disagree with, here's why these claims don't fly under the law, and here's our paper trail for later if we need it. Important note, this motion isn't about saying Blake's facts aren't true. Wayfair's saying, Judge, even if everything she says is true, the law still doesn't let her sue us for it. That's a powerful argument. So in their filing, Wayfair goes through Blake's allegations one by one, focusing on the sexual harassment and retaliation claims at both the state and federal level. And this is where the California angle comes in. They're telling the judge, look, California's Fair Employment and Housing Act, FEHA, is a California law. It doesn't stretch beyond California unless the legislature specifically says it can. Because Blake is a New York resident, the film was shot in New York and New Jersey, and all the alleged misconduct happened outside California. Wayfair's arguing that the FEHA claims should be tossed immediately. So besties, here's the real kicker. California's Fair Employment and Housing Act, the FEHA we've been talking about, isn't a magic law that covers everything everywhere. It's meant for California residents dealing with stuff that actually happened in California. Period. And Wayfair's lawyers lean hard into that point. In their new motion, they're basically saying, Blake doesn't even come close to meeting that standard. And then they start peeling back the layers on something we've chatted about before. Even if you assume her story is true, she never actually pleads an adverse employment action, which is required under both FEHA and Title VII. That's her second cause of action. No adverse action, no retaliation claim. Next up, they go after the connection, or lack of it, between her harassment complaints and this alleged smear campaign. Under both FEHA and Title VII, you have to show a link. He doesn't. She also doesn't show temporal proximity. Basically, the timing between her protected activity, like making a complaint, and the retaliation, like the smear campaign. Wayfair's pointing out that she makes a complaint 1 month and then months later, points to something totally different as proof of retaliation without explaining how they're connected. And this part's juicy because in their filing they really walk the judge through it. She says X happened, then months go by, then she calls Y retaliation, but she never tells us why the two are linked. They also flag something I got dragged for mentioning before, whether she exhausted her administrative remedies. Wayfair's now bringing that exact point to the judge. She didn't do the procedural stuff you're supposed to do first. Then they pivot to her defamation claims. Wayfair's lawyers argue those are protected by privilege, the same kind of privilege they used to knock out defamation claims that had been brought against Wayfair itself. They also say she hasn't properly pled a civil conspiracy at all. From there, the motion gives a neat little recap of her allegations, like a mini timeline, showing that even she admits almost everything happened in New York or New Jersey. And the very first section of the motion zeroes in on those FIHA claims. Remember, these are her 2nd through 7th causes of action: harassment, retaliation, hostile work environment, failure to prevent harassment, and aiding and abetting, all under California's FIHA. Wayfair's telling the court, "Judge, you can't even get there because California law doesn't reach outside California." They start by laying down the rule on extraterritoriality. Basically, California's default assumption that its laws stop at the state line unless the legislature clearly says otherwise. And they're not just saying it. They cite cases, Sullivan versus Oracle and Ward versus United Airlines, to back it up. Then they apply that principle directly to Blake. She's a New York resident. The film was shot in New York and New Jersey. Even in her own second amended complaint, she admits that Justin Baldoni and Jamie Heath were in New York when this alleged harassment went down. The motion even calls her complaint bereft, meaning totally lacking of any allegations that Steve Sarowitz, another defendant she named, did anything from California or ratified anything that happened there. Why does that matter? Because an essential piece of FIHA is that someone within the company with actual authority had to know about the misconduct and then condone it. Basically approve it by ignoring it, laughing it off, or doing nothing to stop it. Without that, you can't meet the ratification requirement under the law. And Wayfair's hammering that home. Blake's a New York resident. She says it all happened in New York and New Jersey, and her complaint doesn't point to anyone in California with authority who knew about it and approved it. No knowledge plus no ratification equals no FIHA claim. In simpler terms, she's accusing them of letting the harassment continue, but she hasn't actually tied that inaction back to anyone in California who had power to stop it. And because of how California law is written, she'd have to make that link to California conduct or California decision makers to even have a shot. So the motion is essentially telling the judge, everything she's talking about happened in New York and New Jersey. Her own papers say Baldoni and Heath were in New York. Steve Sarowitz, also named, is based in Illinois. Nobody she's accusing was even in California when this happened. And that's the heart of their extraterritoriality argument. No harassment in California, no California decision makers involved, and therefore no California FIHA claim. Full stop. Okay besties, buckle up because this is the part where even I had to slow down and say the words out loud. It's a mouthful. Wayfair's lawyers are basically telling the court, plaintiff's FIHA claims are not enforceable. That's their headline. Then they pivot to the backup argument. Even if you pretend for a second that California's laws could magically apply outside the state, Blake still didn't do the one thing you have to do first. Exhaust your administrative options under both Title VII and FIHA before filing a lawsuit. And here's the twist. Because of how she filed with the California Civil Rights Department, the CRD, she never even listed her actual employer. It ends with us LLC in the complaint. It gets even spicier. In the case Lively versus Wayfair, Blake has actually moved to seal her CRD complaint, the very one she'd already leaked to the New York Times. She wants it hidden from you and me so we can't read the right to sue letter or see exactly who she named. But hello, it's already out there. We know from what's been published, and from what Jed Wallace attached in his Texas filing against her, that she did not include It Ends With Us LLC. Instead, she named Wayfair Studios as the employer and listed Justin Baldoni, Jamie Heath, Steve Sarowitz, Melissa Nathan, plus a bunch of PR agents. Tag Group, Jennifer Abel's group, Jed Wallace's group. And that's a huge problem because PR agents aren't her employer under the law. On top of that, in this CRD complaint, she doesn't even clearly allege a retaliatory act, which the defense is now hammering on. Retaliation claims have to fall within a very specific time window, and they're pointing out she didn't. So Wayfair's saying, because she never filed a CRD complaint against It Ends With Us, she never got a right to sue letter for them. She filed against 10 other defendants, but her actual employer, the production company behind the movie, isn't one of them. And under the law, that matters a lot. If you're going to sue for employment discrimination under FEHA or Title VII, you must include your actual employer in your administrative complaint before you can bring them into court. Wayfair's motion highlights this with receipts. That famous 17-point agreement she keeps referencing? Look at the signature line. It doesn't say Wayfair Studios and Blake Lively. Her own attached copy shows it's between It Ends With Us Movie LLC and Blake Incorporated. Wayfair Studios just helped fund it. The movie itself is a separate legal entity. Super common in Hollywood because it shields the parent studio from liability and funnels all the payroll, taxes, and records through the production LLC. She's trying to blur the line and say, they're all the same, they all worked at Wayfair and It Ends With Us. But legally, that's not how it works. That LLC was her employer, not Wayfair Studios. So the defense is running a two-track strategy. For Wayfair, dismiss everything because California's FEHA can't be applied outside the state. For It Ends With Us LLC, even if FEHA did apply, she didn't exhaust administrative remedies and never named us in the CRD, so throw the claims out. It's two separate arguments, but they're both aimed at nuking the same set of claims. Just like a motion to dismiss can give the judge multiple off-ramps, they're stacking reasons so the court has plenty of ways to rule against her. They also double back to the other big weakness. She hasn't properly pled any adverse employment action under either FEHA or Title VII. And here's where the labor law reality hits. In sexual harassment and discrimination cases, if you can't prove some sort of retaliatory act, termination, demotion, loss of benefits, blocked opportunity, your harassment claim alone is brutally hard to win. Courts almost always want to see that retaliation element. So Wayfair's strategy is obvious. If they can convince the judge there's no retaliation, then Blake faces an uphill battle proving the harassment on its own. Under the law, to properly plead retaliation, she has to show 4 things. She engaged in a protected activity, like reporting harassment. The employer knew about that activity. The employer took a materially adverse employment action against her. There's a causal link between the two. And Wayfair's telling the court she hasn't shown any of that. Plus, she's still trying to blur the line between Wayfair and It Ends With Us. But Wayfair isn't even a party to her loan-out agreement for acting services. That leads to yet another point in the motion. Wayfair isn't technically her employer at all. It Ends With Us LLC is. And she hasn't alleged any real adverse action from them either. They go so far as to point out she never claimed she was fired, demoted, lost any benefits, had a blocked opportunity, or suffered any other material change to her employment. Her entire adverse employment action theory boils down to 3 references about a supposed coordinated campaign to cast her in a false light during the film's publicity push. Basically, she's saying the bad press was retaliation. But that publicity started in August 2024. After production had wrapped and after the on-set discord had already spilled into the public eye. That timing alone, the defense argues, blows up her retaliation narrative that they're also stressing that there's no adverse employment action here at all. Blake wasn't even an employee anymore. She was working on a completely different project and these defendants had zero control over her working conditions at that point. And here's where it gets even more striking. Blake Lively is actively moving to seal her own complaint. The same complaint that's already public and linked in a New York Times article. She's telling the court this CRD complaint is confidential and must be filed under seal, but in reality, anyone can literally pull it up online right now. So to Judge Liman, she's insisting it's confidential. Yet the entire thing is already sitting on the internet. In fact, the motion quotes from page 62 of her complaint, the very one that's publicly accessible through the NYT link. And the language she uses in that complaint is dramatic. She says discovering the full extent of Wayfair's alleged retaliatory campaign has left her with no choice but to file this lawsuit. She says she's doing it to set the record straight, to hold Wayfair and its associates accountable, and to shine a light on this new form of retaliation, so it can't be used against other people who speak up about sexual harassment. The irony? She's acknowledging in the very same complaint that she's trying to hide from Liman, a complaint we can all read, that she's claiming some brand new form of retaliation, something that's not even in the current law. That's how wild this is. And even wilder, she's trying to keep all of it under the seal of confidentiality. You can practically hear Wayfair's lawyers telling the judge, "Look at this." She calls it confidential while the New York Times is already reporting on it. This confidential complaint is the entire basis of their article about us. So what Wayfair is saying is that by trying to create a new standard for adverse employment action, Blake hasn't actually alleged any real adverse action against her at all. Their motion systematically goes down the list and points out how poorly pled her FIHA claims are. Then they take on the next point. Even if a smear campaign could count as retaliation, she still hasn't tied that alleged smear campaign to her protected activity. There's no causal link. And under retaliation law, that's mandatory. They remind the judge that to plead retaliation properly, you have to show two things. Keycap 1, that the employer knew the employee engaged in a protected activity, and Keycap 2, that the timing of what happened next was close enough to prove a retaliatory motive. Timing is critical. The retaliatory purpose can be shown directly or indirectly, but usually by proximity in time. And this is where the timeline kills her claim. According to her own case, she first complained in May 2023, but she says the retaliation didn't start until August 2024. That's 15 months later. They even bring in case law to hammer it home. Courts have said 10 months is too long, 7 months can be too long. Here it's 15. Even if they use her all-hands meeting on January 4th as the start of her renewed complaints, that's still a 7-month gap. And she hasn't shown how that 7-month gap proves retaliation or connects to Wayfair's hiring of PR. Wayfair argues the crisis management PR campaign wasn't a punishment at all. It was exactly what any company would do to defend itself from escalating negative publicity. In other words, the PR strategy would have happened regardless of any protected activity. Blake claims hiring these PR people was done to retaliate against her. Wayfair counters, she hasn't even proven a retaliatory motive. In fact, her own allegations suggest the opposite, that the PR response was to defend Wayfair and Baldoni from her team's harsh public criticism and from a wave of bad press surrounding the film's release. She points to text messages as her smoking gun of retaliation, but Wayfair says those texts show no such thing. Instead, they show that by late July 2024, after filming wrapped and after her acting services ended, Baldoni and the Wayfair parties simply consulted a crisis management PR team about how to handle an anticipated storm of negative publicity from Blake over disputes on the It Ends With Us set. Those disputes weren't about harassment complaints. They were about the fight over control of the production, editing, and marketing of the movie. The texts even show the defendants were actively planning ahead. They're saying things like, "We should have a plan in case she pulls the same stunts when the movie comes out. It would help to be ready to refute anything she says, to be armed and prepared for Blake weaponizing feminism." They talk about scenario planning, basically strategizing for the moment Blake and her team might take their grievances public. They even kick around the idea of planting stories ahead of time to shape the narrative. What if we run pieces about how terrible Blake is to work with, just to get ahead of what she's already putting out? They discuss going back and forth with negative accounts, flipping the script, changing the narrative, and staying on message. One of them, Abel, is even asking about the cost of social media mitigation and hiring proactive fan posting to counter negative buzz. And their worries weren't just hypothetical. On the eve of August 6th, the night of the premiere, Blake really did append things. She sidelined Baldoni, told cast and crew members to unfriend him on social media, and refused to be photographed with him. Baldoni and his family were literally banished to the basement until she finished her pre-show appearances. The public frenzy over Baldoni's distress, the cancellation efforts swirling around him, and Wayfair's frantic goal to flip the narrative and repair his reputation. All of that shows up right in the text messages. The whole plan was about protecting him and the company because of what Blake had done at the premiere. That premiere is really the moment everything exploded. Reddit threads started popping up about competing film cuts. Nathan even commented that Blake had boxed herself in with the unfollow stunt and her insistence on no joint photos. Wayfair argues that what Blake calls a smear campaign didn't just materialize to retaliate against her. It began the week of the premiere as a direct response to the negative press she and her team were already generating. The campaign was meant to tamp down speculation about the rift between Baldoni and his cast and crew and to explain why Baldoni was noticeably absent from press events and group photos. Blake herself even admits that the plan wasn't created in response to any one allegation. It was entirely about managing public perception, about Baldoni's fear of what might happen if she unfollowed him publicly or aired grievances during the rollout. And that's the key point. Planning to counter negative publicity and defend your reputation is not the same as retaliation or adverse employment action. That's what Wayfair is hammering. They say Blake has failed to plausibly show the causal link between her protected activity and this PR campaign. They wrap it up with a blunt line. Lively may not like the public criticism she unleashed, but the SAC is devoid of facts showing these efforts to neutralize bad publicity were retaliatory. Without a solid factual basis, her complaint's conclusory allegations of retaliation can't meet the legal test under Title VII or FIHA. That's the punchline to the whole FIHA section. A clean, powerful way to close it out. As for defamation, the defense doesn't even need to spend much time on it. Her defamation claims are based on statements made out of court by Mr. Friedman, the defendant's counsel. But those statements are protected by litigation privilege. The exact same privilege Blake enjoyed when she made her CRD complaint public. Under New York law, there's no invasion of privacy claim either. So there's basically no ground for defamation at all. And finally, civil conspiracy. Under both California and New York law, conspiracy isn't a standalone claim. It only applies if there's a valid underlying tort. The motion points out that Blake hasn't pled any viable underlying torts. Her FIHA claims, Title VII retaliation and defamation all fail. Without a surviving tort, the conspiracy count collapses automatically. To even allege conspiracy, the supposed co-conspirators must be legally capable of committing the underlying tort and owe a duty to the plaintiff. If the underlying claim is barred, there's nothing left to conspire about. The defense urges the court to dismiss it outright, because it can't create a new freestanding liability category. So here's what the defendants are really asking the judge to do. Dismiss the It Ends With Us movie claims, the first cause of action. Dismiss causes 2 through 7 entirely against everyone. Dismiss causes 12 through 15 entirely and dismiss civil conspiracy. What would be left? Just 1 count of Title VII against Wayfair and 2 breach of contract claims. 1 for her loan-out agreement and 1 for the rider she signed with its no retaliation provision. That would transform the case completely. It wouldn't be an employment discrimination case anymore. It would just be a contract dispute between a studio and its client. A totally different fight, and one Wayfair can defend much more easily. There's real bite here. The motion is loaded with arguments that will make it very hard for Blake to respond and to persuade the judge. She'll try, of course, but this filing actually has teeth. She definitely will try, but here's the thing. The judge has already granted a motion to dismiss for Wallace. And while he didn't rule on the full merits of the claims, he made it clear there were weaknesses. The law is the law. If you don't meet the requirements for a proper pleading, the court has to dismiss. And even if this judge denies the motion, the defendants can still appeal. Plus, every one of these filings creates a record of exactly what they believe is wrong with Blake's claims. If the motion is approved, only 2 issues move forward. That whole smear campaign angle? Gone. It won't even be part of the case anymore. It would just boil down to, you breached the contract because you talked about me publicly. And remember, Baldoni never even said anything negative about her. She could easily have breached the contract too. One of the most important details here. Because Blake didn't attach a copy of her actual loan-out agreement, Wayfair filed one under seal. What they told the court is that neither side has produced a signed loan-out agreement. Only an unsigned copy. Think about what that means. If Blake Lively never actually signed her contract, it explains why she didn't attach it to her lawsuit. But it also raises the question. If you don't have a signed contract, what grounds do you even have to sue on? The judge has a lot to consider and Blake has a lot stacked against her. Anyone thinking this motion is automatically going to be denied is missing an important point. The judge's previous decisions on discovery were just about the rules of discovery, not about the facts of the case. Discovery rulings are procedural. They don't touch the core allegations. But here, Wayfair is asking the court to rule on the law itself. And this judge has already shown he's willing to follow the law strictly. That's why he dismissed parts of Wayfair's case earlier, and he could do the exact same thing to Blake's. Honestly, her pleadings are arguably even weaker than Wayfair's were. This is a huge move. I'm actually impressed. It's a smart step for them. If they knock everything out now, the next stage is summary judgment, where they can put even more facts on the record about why Blake's case is baseless. And remember, even if they don't win everything here, they can still go after the same dismissals at summary judgment. This isn't the end, but it could effectively end her case. What do you think? Drop your thoughts in the comments below. Don't forget to give this video a thumbs up, subscribe if you haven't already, and click that bell so you never miss a new update. Thanks so much for watching. Bye, besties.